Juan de la Cruz was charged with a crime of acts of lasciviousness. He filed a petition for bail and was approved by the court. Upon promulgation of judgment where he was found guilty, he jumps bail and failed to appear. What are the consequences of his actions? The judgment shall be promulgated in his absence and he loses the right to appeal. Under Rule 114, Section 21 of the Rules of the Criminal Procedure, when the presence of the accused is required by the court or these rules, his bondsman shall be notified to produce him before the court on a given date and time. If the accused fails to appear in person as required, his bail shall be declared forfeited. My name is Ricky L. Vargas Jr. Good day and God bless.
That is Mr. Ricky Vargas, UNC Dean Solicitor, and I tell you, he's good in answering questions regarding criminal procedure and other law subjects. Sarah G here, your show's host for today, and now for our toughest task in today's video entitled UNC freshman students will attempt to respond to the criminal procedure questions challenge. Yes, you heard it right. And a select group of UNC law students were chosen by our staff, and they attempted to respond to various bar questions and cases involving criminal procedure. And to start with, let us hear from Miss Sophia, first-year student Block D, and here is the question. In prosecution for murder against William, the prosecutor moved for the postponement of the first scheduled hearing on the ground that he had lost his records of the case. The court granted the motion, but when the new date of trial arrived, the prosecutor, alleging that he could not locate his witnesses, moved for the provisional dismissal of the case. If William's counsel does not object, may the court grant the motion of the prosecutor. Why? Sophia?
No, the court cannot grant the motion for provisional dismissal. Section 8, Rule 117, Rules on Criminal Procedure states that a case cannot be provisionally dismissed except upon the express consent of the accused and with the notice to the offended party.
Well done, Miss Sophia. I guess your professor will be very proud of you. And for our number 2 situations in question, this is for Miss M. Rojas and Miss ERIKA NIMO. Here's the situation. While in bicycle race, Mr. A bumped the bicycle of one of his competitors. Mr. B, resulting to the latter hitting the concrete pavement and sent Mr. B crashing headfirst into the sidewalk. Mr. B died as a result. The authorities immediately arrested Mr. A without a warrant and immediately brought him to the inquest prosecutor for the conduct of an inquest. Thereafter, an information for homicide was filed by the inquest prosecutor without the conduct of a preliminary investigation. The next day, Mr. A requested for the conduct of a preliminary investigation. Question number 1. Is the inquest prosecutor's filing of the information without the conduct of preliminary investigation proper? Question number 2. Is Mr. A's request permissible? Explain.
Yes. The inquest prosecutor's filing of the information without the conduct of preliminary investigation is proper. Under the rules of criminal procedure, in case of warrantless arrest, for an offense requiring preliminary investigation, the information may be filed in court even without preliminary investigation, provided that an inquest was conducted by an inquest prosecutor.
Yes, Mr. A's request is permissible. The law provides that after the filing of information or complaint in the court without preliminary investigation, the accused may within 5 days ask for preliminary investigation with the same right to adduce evidence in his defense. Hence, Mr. A may request for a preliminary investigation.
Thank you very much for the 2 students who attempted to answer question number 2, and well done. And for our situation, question number 3, it is for Ms. Che San Pascual. And here's the situation. X is charged with illegal possession of firearms under an information signed by a provisional prosecutor. After arraignment, but before pre-trial, X found out that the provisional prosecutor had no authority to sign and file the information as it was the city prosecutor who had such authority. During the pre-trial, X moves that the case against him be dismissed on the ground that the information is defective because the officer signing it lacked the authority to do so. The provisional prosecutor opposes the motion on the ground of estoppel as X did not move to quash the information before arraignment. If you are the judge, what would be your resolution?
I will deny the motion to quash. First, a motion to quash on the ground that the fiscal has no authority to file the information should be raised before arraignment. Otherwise, it is waived. Second, the handling of the prosecutor's authority, particularly as it does not appear on the face of the information. There is no connection to the trial court's power to hear and decide a case. Hence, Section 3, Letter D, Rule 117, requiring a handling prosecutor to secure prior written authority or approval from the provincial, city, or chief state prosecutor before filing an information with the courts. It may be waived through the accused. It may be waived by the accused through silence, acquiescence, or failure to raise such ground during arraignment or before entering a plea. If at all, it's such deficiency is merely formal and can be cured at any stage of the proceedings in a criminal case.
Thank you so much, Ms. San Pascual. And for our situation in question number 4, it is for Ms. SERLYN DACARA. The situation is, Thomas was criminally charged with serious physical injuries allegedly committed against Darwin. During the pendency of the criminal case, Darwin filed a separate civil action for damages based on the injuries he had sustained. Thomas filed a motion to dismiss out that when the criminal action was filed against him, the civil action to recover the civil liability for the offense charged was also deemed instituted. He insisted that the basis of the separate civil action was the very same act that gave rise to the criminal action. Rule on Thomas' motion to dismiss with brief reason.
Thomas' motion to dismiss on the ground of litis pendentia should be denied. In cases of physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such a civil action shall proceed independently of the criminal action according to Article 33 of the Civil Code and hence may not be dismissed on the ground of litis pendentia.
Impressive answer, Ms. SERLYN. And to continue, this is our number 5 question. This is for Mr. Arthur. And the question is, should a new procedural law always be given retroactive effect if it favors the accused?
Procedural law may be applied retroactively, and it is applicable to actions pending and undetermined at the time of its passage. It is retroactive only in that sense and to that extent. However, under appropriate circumstances, courts may deny the retroactive application of procedural laws in the event that to do so would not be feasible or would work injustice, such as in the case of People v. Lacson, when the Supreme Court denied the retroactive application of a new rule to favor the accused, since the new statute was intended to benefit both the state and the accused, because while the latter is entitled to the right for speedy trial, cases must also not be recklessly dismissed on mere technicality or as prejudice against the state.
Thank you, Mr. Arthur, and well done too. And for our number 6 situation, number 6 question, it is for Mr. Darren Tupas and EMAN CAUBANG. And here's the situation. In a buy-bust operation, 30 kilos of shabu were seized from Jose and Jessie. They were arrested and placed on inquest before Prosecutor Magtanggol, who ordered their continued detention. Thereafter, the information for the sale and distribution of shabu was filed in court. When arraigned, Jose and Jessie pleaded not guilty to the charge. During pre-trial, counsel for both of the accused raised for the first time the illegality of the arrest. The case proceeded to trial. After trial, the court scheduled the promulgation of judgment with notice to both the accused and their counsel, Attorney Di Mayuga. During the promulgation, only Jose and Attorney de Mayuga were present. Both the accused were convicted of the crime charged. Question number 1 is that, was the challenge to the validity of the arrest timely raised? And question number 2, what is the remedy available to Jessie, if any, to be able to file an appeal?
No, the challenge to the validity of the arrest was not timely raised. As a rule, the accused may question the validity of his arrest through a motion to quash before he enters his plea. Otherwise, the objection is deemed waived and an accused is prevented from questioning the legality of his or her arrest. This is based from Veridiano versus People of the Philippines, GR number 200370, June 7, 2017.
To be able to file an appeal, Daryl should surrender and file a motion for leave of court, stating therein the reasons for his absence during the promulgation of a judgment. As a rule, the accused who fails to appear at the promulgation of a judgment of conviction should lose the remedies available under the rules of court, such as the filing of a motion for new trial or reconsideration, or by filing an appeal from the judgment of conviction. The rules of court, however, allow the accused to regain his standing in court to avail any of these remedies by his surrender or by filing a motion for leave of court.
Thank you, Mr. Darren and Mr. Eman, for answering our question number 6. And for question number 7, here's Ms. Janice CANACO. And the question is, in an information filed before the regional trial court, Mr. C was charged with carnapping for supposedly taking the motorcycle of Mr. O and joyriding with it around the city. When Mr. C was arraigned, he entered a plea of not guilty to the charge. After the prosecution rested its case, Mr. C proceeded to file a demurrer to evidence. The demurrer was denied by the RTC. Question number 1. Would Mr. C be allowed to present evidence in his defense after the denial of his demurrer? Explain. And for our question number 2, assuming that the demurrer was granted by the RTC and the prosecution's motion for reconsiderations thereto is denied, what is the prosecution's further procedural recourse? And explain.
No, Mr. C would not be allowed to present evidence in his defense after the denial of his demurrer. Under the rules of criminal procedure, if the court denies the demurrer to evidence filed in leave of court, the accused may adduce evidence in his defense. When the demurrer to evidence is filed without leave of court, the accused waives the right to present evidence and submits the case for judgment on the basis of the evidence for the prosecution. In this case, there is no showing that the demurrer to evidence was filed with leave of court by Mr. C. The prosecution has no further procedural recourse when a demurrer to evidence is granted. The case is dismissed and the effect is an acquittal.
Thank you, Ms. Janice. And to continue, here's our question number 8 from Mr. Eddie Labios. And the question is, in an information, a man was charged with having forcible carnal knowledge of a 16-year-old woman. The information did not contain any allegation concerning the victim's relationship with the accused. During the direct examination of the victim, the prosecution was able to elicit information that the accused was the 16-year-old woman's father. The defense counsel failed to object to the testimony, having also been surprised by the revelation. After trial, the judge convicted the accused of simple rape and imposed the corresponding penalty. The prosecution moved for reconsideration, claiming that the accused should be convicted of a qualified rape because the relationship between the victim and the accused was proven, even as it had not been alleged in the information. Is the prosecution legally correct?
No, the prosecution is not legally correct. Under Rule 110, Section 8 and 9 of the Rules of Court, the information shall specify its qualifying and aggravating circumstance to enable a person of common understanding to know what offense is being charged. any qualifying and aggravating circumstance not alleged, though proven during trial, shall not be considered by the court.
Thank you for that, Mr. Eddie. And to continue, here is our question number 9. This is for Ms. Isa Calzado. Ms. Isa, this is your question. May a prosecution witness like Mary Jane Veloso, who was convicted of drug trafficking and sentenced to death by the Indonesian government and who is presently confined in a prison facility in Indonesia, testify by way of deposition without violating the constitutional right to confrontation of a witness by the accused?
Yes, interestingly, nowhere in the present rules of the court in a criminal procedure does it state how a deposition of a prosecuted witness who is at the same time convicted of great offense by final judgment and imprisoned in a foreign jurisdiction may be taken to perpetuate the testimony of such witness. The rules in particular are silent as to how to take the testimony of the witness who is unable to testify in an open court because he is imprisoned in another country.
Thank you for that, Ms. Isa Calzado. And for our question number 10, this is for Mr. Joshua Sinuba. And here is your question. In 2017, Cuvida, who was recklessly driving his car, hit and severely injured Putian. A criminal case for reckless imprudence resulting in serious physical injuries was filed against Cuvida. Putian did not reserve the filing of a separate civil action. In 2021, the criminal court rendered a judgment acquitting Cuvida, finding that Cuvida was driving his car with utmost diligence and care. Today, Putian filed a civil case for torts with damages against Cuvida. Will the civil case prosper?
No, Putian's civil case for torts against Cuvida will not prosper. Under the rule on the criminal procedure, the rule that the pendency of the criminal action suspend the running of the prescriptive period of the civil action does not apply to an independent civil action. This is because the filing of an independent civil action is not deferred by the pendency of the criminal case. Here, Putian's civil case for torts against Cuvida is an independent civil action since it is an action for quasi-delict. Hence, the running of its prescriptive period was not suspended. However, Putian filed the civil case only today when more than 4 years had passed from the 2017. Thus, the civil case for torts is barred by the prescription. Hence, Putian's civil case will not prosper.
And that is Mr. Joshua. And for our question number 11, this is for Mr. Rodante Yanesa and Mr. Gregorio Manuel Don. And here is your question. Mr. P was charged with plunder with the Sandigan Bayan along with several government officials. Before his arraignment, he filed petition for bail. This was objected to by the prosecution, which insisted that he should first be arraigned before he applies for bail. Considering that the grant of bail will result in the accused fleeing the court's jurisdiction. Question number 1. Is Mr. P's petition for bail a matter of right or discretion? Question number 2. Is the objection of the prosecution valid?
Mr. P's petition for admission to bail is a matter of judicial discretion, as the prosecution has yet to prove that the evidence of guilt in his case is strong, considering that plunder is punishable by death. If Mr. P's guilt is proven to be not strong, petition for bail for Mr. P becomes a matter of right, but during the pendency of the hearing, it is a matter of judicial discretion. If Mr. P's guilt is proven to be strong, as showed by the evidence adduced by the prosecution during the hearing, Mr. P's petition for admission to bail is no longer a matter of judicial discretion, much less a matter of right. In such case, denial of bail is a matter of course.
A follow-up question on the case discussed by Attorney Patrocinio. Is the objection of the prosecution valid? The answer is no. The arraignment of an accused is not a prerequisite to the conduct of hearings for the petition for bails. A person is allowed to petition for bail as soon as he is deprived of his liberty for his arrest or his voluntary surrender. An accused did not wait for his arraignment before filing a petition for bail.
Thank you so much, Mr. Rodante and Mr. Gregorio. And for our number 12 question, this is for Ms. JERIELYN Doctor. And here is your question. In a buy-bust operation, the police operatives arrested the accused and seized from him a sachet of shabu and an unlicensed firearm. The accused was charged in one information, 2 violations, one for violation of the Dangerous Drug Act as amended, and another for illegal possession of firearms. Question number 1. Was the seizure of the firearm valid? And for question number 2, if you are counsel for the accused, what will be your remedy?
Yes, the seizure of the firearm was valid because it was seized in the course of a valid arrest in a bypass operation. Section 13 of 126 Rules of Court, a search warrant was not necessary if a person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant.
Thank you so much, Ms. JERIELYN Doctor. And for our question number 13, this is for Ms. NELIA Britannico. And the question is, after having been filed by the Ombudsman of 2 information charging her with violating RA 3019 and malversation under Article 217, Safra, a private petitioner, filed a motion for demurrer to evidence, alleging that the prosecutor failed to present proof of his guilt. The demurrer was granted by the RTC, ruling that the testimonies of the witnesses are insufficient to warrant conviction, thus acquitting her. The respondent filed a petition for certiorari under Rule 65, assailing her acquittal. The CA granted the petition, revoking the lower court's order granting Zafra's demurrer. The Court of Appeal found Judge Mupas committed grave of abuse of his discretion through his grant of Safra's demurrer. Question: was the RTC erred in granting the demurrer?
Yes, the CA was correct in ruling that the grant of Safra's demurrer was attended by grave abuse of discretion. The prosecution's evidence was prima facie sufficient to prove the criminal charges filed against Safra. The lower court improperly examined the prosecution's evidence and erred in believing that the crime charged could only be committed through positive acts. As correctly held by the CA, malversation may be committed either through positive acts or passively through negligence by allowing another to commit it. As a general rule, an order granting a demurrer to evidence, however, amounts to acquittal. And however, when there is a finding that there was a grave abuse of discretion on the part of the trial court in dismissing a criminal case by granting a demurrer, its judgment is considered void. Petition is denied.
Thank you so much, and that is Ms. NELIA Britannico. And for our next question, that's question number 14. This is for Ms. Andrea Saboco, and here is your question. SPO1CNC filed with the MPC in Quezon City a sworn written statement duly subscribed by him, charging RGR, the actual resident of Cebu City, with the offense of slight physical injuries allegedly inflicted on SPS. The judge of the branch to which the case was referred thereupon issued an order declaring that the case shall be governed by the rule on summary procedure in criminal cases. Soon thereafter, the judge ordered the dismissal of the case for the reason that it was not commenced by information as required by the said rule. Sometimes later, based on the same facts giving rise to the slight physical injuries case, the city prosecutor filed with the same METCQC an information for attempted homicide against the same RGR. In due time, before arraignment, RGR moved to quash the information on the ground of Dr. Jobardi, and after due hearing, the judge granted his motion. Was the dismissal of the complaint for slight physical injuries proper? That is question number 1. And was the grant of the motion to quash the attempted homicide information correct? That is our question number 2.
Yes, the dismissal of the complaint for slight physical injuries is proper because in Metropolitan Manila and in chartered cities, the case has to be commenced only by information. However, the grant of the motion to quash the attempted homicide information on the ground of double jeopardy was not correct because there was no valid prosecution for slight physical injuries.
Thank you so much, Miss Andrea Sabocco. And for our last question, here is Mr. Paul Jun ISIP.
Jurisdiction, finality of the judgment. Situation. Mariano was convicted by the Regional Trial Court for raping Victoria and meted the penalty of reclusion perpetua. While serving sentence at the National Penitentiary, Mariano and Victoria were married. Mariano filed a motion in said court for his release from the penitentiary on his claim that under Republic Act No. 8353, his marriage to Victoria extinguished the criminal action against him for rape, as well as the penalty imposed on him. However, the court denied the motion on the ground that it had lost jurisdiction over the case after its decision had become final and executory. Question. Is the filing of the court correct? Answer, no. The court can never lose jurisdiction so long as its decision has not yet been fully implemented and satisfied. Finality of a judgment cannot operate to divest a court from its jurisdiction. The court remains an interest in seeing the proper execution and implementation of its judgment, and to that extent may issue such necessary and appropriate for this purpose. Question number 2. What remedies should the Council of Mariano take to secure his proper and most expeditious release from the National Penitentiary? Answer. To secure the proper and most expeditious release to Mariano from the National Penitentiary, his counsel should 1. File a petition for habeas corpus for the illegal confinement of Mariano under Rule 102, or B. File a motion in the court which convicted him to nullify the execution of his sentence or the order of his commitment on the ground that a supervening development had occurred despite the finality of the judgment.
This concludes the challenge for today's video. I sincerely hope you all like and learn more about our subject. And I want to congratulate all of the UNC Law students who took part in this challenge, and you guys all performed fantastic. Again, this is your host Sarah G, bidding you farewell and hope to see you again next week. Always keep in mind that ignorance of fact is an excuse, but ignorance of the law is not excuse. Thank you so much and goodbye.
Dear Proslex,
Maraming salamat po
sa 6 na buwan na pagturo,
sa pag-unawa at sa pagpasensya,
at sa inspirasyon na balang araw.
Kami rin ay magiging isang matuwid na abogado katulad mo.
You are truly an inspiration, Proslex.
Hi Pros! Hashtag Best Law Professor Prosecutor of 2022.
Thank you, Proslex, for your passion to impart your knowledge to us.
ang samuya man nagamagama sa klase sa kasagub chat.
Senyales kang dakulang interes ang makanood sa iyo.
Your teaching style creates an atmosphere.
Thank you, Pros, for giving us conducive learning situation in this generation.
Maraming salamat po, Proslex.
Sa pagtuturo ng pagkakaiba ng digest sa digest.
Na bawal mag-start sa so ang isang sentence.
And more importantly, to be humble.
And never give up.
Bye for now.
See you next time, Pros.
Merry Christmas and Happy New Year po.
Sa imo, asin sa mga padangat mo sa buhay.
God bless you always and everything that you do.
Diyos na po ang magbalos.